Hi, this is Carl Leopson at the University of Arizona. Regardless of how much good proactive planning you do and great classroom discipline you have in place, there's going to come a time when you'll experience some disciplinary situations with kids who are identified with special needs. And when that happens, those kids fall under the discipline provisions of IDEA. Now, the way that kids with special needs are dealt with in schools in terms of school discipline is very different and can be very different from the way that schools can discipline kids who are in the general population. So, while we're doing this session, it's not going to make you an expert. Spending some time talking about this will help you understand the discipline provisions. If you ever get into a tough situation and you're working in a school, best for you to contact your district supervisor or your district special ed administrator. They will send somebody a run-in to help you understand exactly how to handle the case. But here's what we're going to do. We're going to walk through the resources at the Center for Parent Information Resources. Great website, does a great job of presenting the IDEA discipline provisions. And we're going to stop periodically and I'll present a scenario and ask you some questions. You'll be able to stop the video, try to answer the scenario, and then we'll come back and we'll do a little more. Hopefully looking at the scenarios will help you understand the discipline provisions a little better. So IDEA's discipline provisions were first introduced in 1997 and there was an incredible kickback against them because they were really confusing. And they were streamlined in 2004. Although when you see how complicated they are, you're going to wonder how much they've actually been streamlined and how much more difficult could it have possibly been from 1997 to 2004. IDEA, it says, addresses the extent to which schools may take disciplinary action when a child with disabilities violates a local code of student conduct. What that means for the school is, first, they better have an identified code of conduct. And they better make sure that everybody gets it. Usually kids have to sign for it and their parents have to sign. And that you can't take disciplinary action against a kid if it's for something that's not in the code of conduct. So, first things first, make sure you have a copy of your school's code of conduct. I'm not talking about disciplinary actions you take in your own classroom. I'm talking about the possibility of suspending a student for some kind of action or considering expulsion for some kind of action. First time violation, there's something called the 10-day rule, and it's been interpreted in different ways in IDEA across the years. And there are a couple different 10 days involved, and that's why it's confusing. But one of them is that a child can be removed to some other setting or suspended for not more than 10 days in a row. All right? And to the extent that those same things are done to kids who don't have disabilities. Once a school bumps up against that 10 days, then things start to look a little iffy. So, does a student have to continue to get services during the 10 days? Not during the initial 10 days, all right? Because during those first 10 days, they can be disciplined, receive consequences that any other student would receive. And the school doesn't have to make arrangements to provide them with special education services during that time period. However, once that school passes the 10th day, or beginning with the 11th day, the school, regardless, for a student with special needs, has to start providing some of the special education services for that student, and we'll talk a little bit more about that later. Sarah is a second grade student with ADHD, identified for special education under the category of other health impaired. She receives services that include supplementary reading instruction and a behavior plan designed to monitor and improve her engagement in classroom instruction. But things start to happen with Sarah. Sarah gets in a fight with another student on the playground, and no one is seriously injured. She is sent to the principal, who cites the code of conduct regarding fighting and suspends Sarah for 6 days. This is the first suspension of the year for Sarah, so she is now a cumulative 6 days. Can the school suspend Sarah? And does the school have to provide special education service to Sarah during her suspension? Think that over for just a second and then come back and we'll talk about it. The first thing we've looked at is Sarah getting in a fight. No one is seriously injured, and you'll see that that's an important piece of information later. And she's sent to the principal, who cites the code of conduct regarding fighting and suspends Sarah for 6 days. And it's her first suspension. Can they suspend her? Well, yes, they can. And they can treat her with a suspension just as they would treat any other student under these circumstances. And do they have to provide services? No, in fact they don't, because she's been suspended for so far less than that 10 days. All right. Here's an issue. If a kid gets suspended for 10 days, let's say they kick kid out of school for 10 days, and then kid comes back and kid gets in another fight and they kick him out, can they kick him out for another 10 days? They've gone past the 10th day. Well, one thing they immediately have to do if they're going to try to do that is provide the kid with services. Okay. Second, could they kick him out another 10 days? Yes, you could, right? But a couple things have to happen. It's got to be done on a case-by-case basis. You've got to determine whether or not this is a change in placement, and that's really important terminology. Because when there is a change in placement, meaning you're changing where this kid is going to receive their services. If you're suspending in a serial manner, or you're suspending lots of times for long periods of time, then it's considered a change in placement. If you suspended a child for 2 days for cursing at the teacher, and then another 2 days for cursing at the teacher, suspended him again 2 days for cursing at the teacher, and again 2 days for cursing at the teacher, that's only 8 days. But somebody could argue that that is a systematic series of suspensions and that it is a change in placement, even though you could suspend the kid for another 2 days and not have to provide services at the same time. So I think with the revisions of IDEA's discipline provisions in 2004, there was more emphasis on case-by-case determination because principals and district personnel felt their hands were tied. Let's say Sarah has returned to school. However, 2 weeks later she gets in another fight on the playground. Again, no one is seriously injured, and we'll see why that's important later. The principal suspends Sarah for another 6 days, and that makes 12 days of suspension. Can the school suspend Sarah for the next 6 days? And does the school have to provide special education services during Sarah's suspension? So stop the video for a moment. Consider those questions and how you would answer them if the principal came to you as a special education professional. What would be your guidance? Be back in just a minute and I'll try to answer them for you. So Sarah's gotten in some more trouble, unfortunately. Sarah's returned to school. 2 weeks later, she gets in another fight on the playground. Again, no one is seriously injured. The principal suspends Sarah for another 6 days. That makes 12 days of suspension. Can the school suspend Sarah for 6 more days? Yes. Most likely they can. It goes past the 10 days. But they can suspend her for another 6 days. In some districts, once you go past those 10 days, they may ask you to do a manifest determination, which is what we're going to learn about in the next section. In some districts, they might not ask you to do a manifest determination quite yet. And does the school have to provide special education services during SERP suspension? Yes, they do, because they've gone past the 10th day. So starting with that 11th day, they have to work out some way to be providing services to Sarah. Now, I used to work in a district as an itinerant behavioral technician of sorts. And so one of the jobs that I had was to help provide educational services for kids who had actually been kicked out of school, sent home, gone past the 10th day, and people, including the parents, agreed that that was still okay, but we had to provide some of the services. And so I went to the home and provided some services. Here's what can happen. If a decision is made to change a child's placement because of a violation of the Code of Conduct, meaning this kid is suspended, there's a pattern of suspensions, like 2 days, 2 days, 2 days, 2 days, all for the same thing. And that really should try not to let that happen. If that's happening, something's wrong with the system that you have at school. If you notice the kids get in trouble for the same thing over and over, you might as well start working on the problem, because the law is going to force you to work on the problem anyways. And it's just the right thing to do. You have to do something called a manifest determination. And what that means is a group gets together, and it's probably principal, teachers. It's like the IEP team, but it doesn't have to be the IEP team. It's really a decision made by the principal and the parent, but it usually is the IEP team, although often the district, if it's a larger district, will send in somebody who's a specialist in this and who understands it. But the notion is to figure out whether or not what the child had done for that infraction is a manifestation of their disability. I sat in once on a manifest determination meeting for a child with ADHD who had brought a knife to school. Okay, so a knife with a blade over 2.5 inches, you can't bring to school. And this kid had it. People saw it in his backpack, turned him in. He said he just forgot. And it had been past 10, it was past 10 days of suspension for him. He also had a series of suspensions. And so we had to hold a manifest determination. And we sat down and we talked. Turns out this kid forgets all kinds of stuff. All kinds of stuff shows up in his backpack, and he probably really didn't mean it. And it was determined that the knife in his backpack was a manifestation of his disability. So what happens? Let's start with the easy part. If you say, no, it wasn't a manifestation of his disability, he just decided he wanted to bring a knife to school because he's a bad kid, or because he was going to try to hurt somebody, or he was trying to show off, and that's not part of his disability, then the school is able to discipline that kid as they would any other kid. Okay? But they still have to provide services, but they can suspend. Right? If the answer is yes, this child's bringing the knife to school was a manifestation of their disability, then the kid actually can't really be suspended. They have to be returned to the placement that they're in, because it's considered that basically they didn't do anything wrong. Okay? And two other things have to happen. You've got to do a functional behavioral assessment, figure out why this kid is doing what they're doing, and then a behavior intervention plan, right? So Sarah returns to class after her suspension. 3 weeks later, she gets in yet another fight, this time in the lunchroom. Again, no one is seriously injured. The principal suspends Sarah for 6 more days. That makes 18 days of suspension, and 3 in a row for the same behavior. Given the pattern of suspensions, can the school actually suspend Sarah for 6 more days? If not, what must they do? Does the school have to provide special education services while they're making decisions about Sarah? And what other important decision-making process has to take place when there is considered to be a change in placement related to a disciplinary issue? Stop the video for a second and think about it, and then I'll get right back to you and we'll talk about it. Okay, poor Sarah. She keeps getting in trouble. She comes back to school. Clearly there is a pattern, right? There is a pattern of suspensions for this kid, and a lot of days. In fact, it's never gonna, you're rarely gonna get a kid who's gonna have this many days of suspension, right? Who is a student in special education. Most schools try not to go past the 10. They try to use them very sparingly across the year, okay, so that they don't have to get into doing manifest determinations. So can the school suspend Sarah for 6 more days? We don't know. They may just have to leave her in her placement where she is right now while they make the decisions and continue to provide her with services. In a lot of situations, schools will try to get the permission of the parent to suspend the student and have them in some other setting until the decisions are made. But I think it could go either way. And what other important decision has to take place? Well, there has to be a manifest determination at this point because there's a pattern of suspensions. So and you need to get that done within 10 days of the action being taken, right? Special circumstances. So we're finally getting to that issue of no one was seriously injured, okay? Because there are 3 situations in which a school has a little broader authority. I say broader authority, but they can do something more drastic. And that was added into the 2004 regulations. A child can be moved into an interim alternative education setting, an IAES, for up to, but not more than, 45 days if they brought a weapon on campus, if they knowingly possess, use, sell, or solicit the sale of controlled substances, and if they have inflicted serious bodily injury on another person while at school. So weapons, drugs, serious bodily injury, those are the special circumstances. Committee determines in our previous incident in a manifest determination that Sarah's fighting in the incident is linked to her disability. So if you remember, she got another fight, and this time it was in the lunchroom, and the school decides that through a manifest determination that Sarah's fighting is linked to her disability. What is it that they've got to do? 2 things that they've got to consider right away. Manifest determination is not just a consideration of whether or not the behavior was a manifestation of the child's disability, but was it a direct result of the school's failure to implement the IEP? So in the example I gave earlier with the child bringing the knife to school, let's say there was something in the child's IEP that said, well, one service we're going to provide to this kid is we're going to check his backpack every morning because he's really forgetful. And so we're going to check his backpack every morning for like contraband that he might accidentally bring to school. And it turns out, well, nobody checked it. And then he ends up with a knife at school. It's going to be the school's responsibility. But what do they have to do in Sarah's case? Well, the 2 things they have to do if they determine that that her fighting is linked to her disability, they have to make sure that she has a function-based intervention or a functional assessment and a function-based intervention plan in place, right? So those are the 2 things they have to do for her. Aside from the fact that throughout they have to provide her with services, and she goes right back to her educational setting. Can you see why now that schools employ people who are experts in these areas and really highly prize teachers, special education teachers who understand and have experience with these rules and can apply them appropriately? You may find as a special education professional that you're really interested in serving the needs of the school in these cases, serving the needs of the family, that you're a good communicator in meetings. You may find that this would be a great role for you. You may find that when a school has an opening for someone to troubleshoot in that school district, that you want to apply for it. And there are ways to resolve these disputes, but just understand that when you give the parent their rights and you're explaining their rights to them, one of them is that they can disagree with you, and if they do, they can ask for an expedited hearing, in which case a hearing officer is appointed. Here's another career opportunity, but most of the time hearing officers are lawyers. They're lawyers in practice, not necessarily judges, but they are lawyers in practice or retired who have had special training in these laws and procedures of IDEA and are on a special list that a state will hold. And when someone makes a complaint from the district that goes up to the state, then the state will go to the list and either find a hearing officer or ask people in the district to choose a hearing officer, trying to make sure they get someone who's impartial and fits their needs. If you want to, interesting, go Google list of special education hearing officers, and you'll find for the different states you'll often find a list of their hearing officers. If a hearing officer says no, you can't, this kid's bringing a knife to school was part of their disability, you need to put the kid back in class, then the LEA can also appeal that. So Sarah returns once again to her classroom. 2 weeks later, she's in another fight. This time, the other student receives a broken arm in the fight. You think I make all these things up out of nothing. This is actually similar to a number of cases that I was involved in when I was an itinerant behavioral specialist. So, think about this. Here's a kid who's been in a series of fights, series of suspensions. 2 weeks later, she's in another fight. This time, the kid gets their arm broken. What are the school's options for removing Sarah? Does the school have to provide services while decisions are being made? If there is a manifest determination, and it's determined that Sarah's behavior is not related to her disability, but the parent disagrees, what recourse does the parent have? And if a hearing officer finds in favor of the parent, does the school have to return Sarah to the regular classroom? What are the options for the school? Chew on that for a minute. We'll come back one last final time. All right, so this time, poor kid with a broken arm. But clearly something bad's going on with Sarah too. But what are the school's options? Well, one thing they can do, since someone was injured, right? Remember, weapons, drugs, serious bodily injury equals the opportunity or the possibility of a 45-day alternative interim placement for this student in some other setting while everybody gets their act together. Okay? Does the school have to provide services? Yes, they do have to provide services. It's kids along past 10 days. And if a manifest determination hearing is held and it's determined that Sarah's behavior is not related to her disability. So the school says, no, this fight wasn't related to her disability. Something else was going on. It'd be really hard to make that argument at this point after they'd already determined previously that it was. But I wouldn't necessarily be completely surprised. But the parent disagrees. What recourse does the parent have? Parent can, through due process, request an expedited hearing with a hearing officer. And if a hearing officer finds in favor of the parent, does the school have to return Sarah to the regular classroom? What are the options? Well, the school can either return her to the regular classroom, or the school can appeal that decision. I don't know if we need to go any deeper than that. I haven't seen many cases, frankly, that have gone much deeper than one round to a hearing officer, and frankly, I've only seen about 2 of those in my 25-year career. This is Carl Leopson, University of Arizona, and I'll see you again online.